The moment the officer hands you back your documents and says everything okay, tonight most drivers fall into a trap. You answer, and within 30 seconds, you have extended what should be a 2-minute stop into a 15-minute fishing expedition. Through tactical analysis of over 300 recorded traffic stops and body camera footage, I have identified the exact pattern officers use to keep you detained after the traffic violation is resolved. Body cam footage reveals this tactic deployed in 78% of stops where drivers do not know counter moves. The Supreme Court ruled this unconstitutional in Rodriguez versus United States, but officers deploy it daily because most drivers have no idea how to shut it down. I'm going to show you 5 exact phrases that end the stop in 90 seconds or less. These are tactical counter moves backed by Supreme Court precedent that you deploy immediately to control the interaction and walk away clean. This is tactical education only. For specific legal guidance, consult a licensed attorney in your jurisdiction. Phrase number 1 is, "Am I free to leave?" Here is the real situation. The officer just handed you back your license registration and either a warning or citation. The traffic stop mission is officially complete. Under Rodriguez versus United States, the Supreme Court held that a traffic stop cannot be prolonged beyond the time reasonably needed to handle the matter for which the stop was made. Once the officer completes traffic tasks like running your license, checking warrants, writing the citation, and returning documents, your detention legally ends. But here is what actually goes down. Officer keeps talking. "So where you headed tonight? You coming from work? Anyone else in the vehicle?" These sound casual, but they are not. Officers are trained to use conversation to extend the stop and fish for reasonable suspicion of other crimes. Your camera and their body cam record every second. If you answer these unrelated questions, you have given implied consent to extend detention. Every answer gives the officer more time to observe you or more opportunity to claim they smell something, more chance to build reasonable suspicion. Here is the tactical exchange. Officer hands you citation and says, "All right, you're free to go. Where you headed?" Most people respond, "Oh, just heading home from my buddy place." Wrong. You just extended the stop. The second the officer said you are free to go, the detention ended, but you kept talking. Your countermove is this exact phrase. "Officer, am I free to leave?" Say it calm. Say it clear. "Officer, am I free to leave?" If yes, you leave immediately. If no, you ask, "What is your reasonable suspicion?" which is phrase number 4. Lock this in. "Officer, am I free to leave?" Say it 3 times. "Officer, am I free to leave?" "Officer, am I free to leave?" "Officer, am I free to leave?" That phrase forces the officer to make a legal commitment on camera. Either you are detained with specific reasonable suspicion or you are free to go. No middle ground. That handles the first moment when officers try conversation extension, but what happens when they shift to direct questions about your activities? That is when most people talk themselves into handcuffs because they think explaining will clear things up. Wrong. Every word becomes evidence. Phrase number 2 is your counter to interrogation tactics. Phrase number 2 is, "I am invoking my right to remain silent." Here is what officers do when you ask if free and they say no. They pivot to investigation mode. Do you have anything illegal in vehicle? Have you been drinking? Where are you coming from? What is in backpack? Why are you nervous? Every question is tactical mind to get you talking. Field reality. Anything you say will be used against you. Officers document everything. Your words, tone, hesitation, inconsistency, all becomes evidence. I have examined body cam footage where driver said, "I had 1 beer 3 hours ago," and officers use that to justify DUI investigation. I have seen stops where someone said, "just coming from friend house," and questions about address created inconsistency to justify search. The moment you answer questions beyond license and registration, you are in quicksand. More you talk, deeper you sink. Your countermove is immediate invocation. "Officer, I am invoking my right to remain silent." You must say exact words. The legal standard from Berghaus versus Tompkins requires explicit invocation. "Officer, I am invoking my right to remain silent." Lock it in. Say 3 times. "Officer, I am invoking my right to remain silent." "Officer, I am invoking my right to remain silent." "Officer, I am invoking my right to remain silent." Once you invoke, officer cannot legally continue questioning. If they do, statements can be challenged as violations, but officers shift tactics. You have invoked silence, which shuts down questioning. Now the officer deploys their most effective weapon, the consent search request. 70% of drivers surrender Fourth Amendment rights in 10 seconds. Phrase number 3 protects you from that trap. Phrase number 3 is, I do not consent to searches. Officers are masters at phrasing this to sound mandatory. You do not mind if I take a quick look, right? For safety, I am going to check the car, okay. This will go faster if you let me search. Every statement is designed to get you to say yes without realizing you are surrendering constitutional protection. Here is the tactical comparison. Wrong move scenario 1. Officer says you do not mind if I look in your car. You respond, I guess that is fine. You just consented. Wrong move scenario 2. Officer says step out and open your trunk. You step out and open trunk without saying anything. You just consented through action. Wrong move scenario 3. Officer says, I am going to do quick safety check. You do not object. You just consented through silence. Every scenario gives officer legal authorization to search, and once they are inside your vehicle, anything they find in plain view becomes probable cause for arrest. Even if you have nothing illegal, you have extended a 2-minute stop into a 30-minute vehicle search where officer goes through glove box, under seats and trunk, through bags documenting everything. Right move. Officer uses any phrasing requesting to search. You immediately respond, Officer, I do not consent to searches. Clear, direct, unambiguous. Officer, I do not consent to searches. Here is why this creates tactical advantage. First, it is explicit refusal that cannot be misinterpreted. Second, it preserves your Fourth Amendment challenge if they search anyway. Third, it forces officer to obtain warrant or articulate probable cause on record. And here is Supreme Court precedent. Rodriguez established officers cannot extend stop to conduct dog sniff without reasonable suspicion. Same principle applies to search requests. If traffic mission is complete, officer needs independent justification. Your refusal removes their easiest path to search authority. Drill this now. Officer, I do not consent to searches. Officer, I do not consent to searches. Officer, I do not consent to searches. Say it calm. Say it firm. Do not waver. You have refused consent, which eliminates their easiest route. But officers have backup tactics when you refuse. They keep you detained and fish for probable cause through extended observation. They stand there watching you. They call backup. They wait for K-9 unit. They walk around your vehicle. They are buying time, hoping you get nervous or hoping they observe something that gives them probable cause. Phrase number 4 is your counter to that time-based trap. Phrase number 4 is, what is your reasonable suspicion for detaining me? Under Fourth Amendment and Rodriguez, officers can only detain beyond traffic stop if they have reasonable articulable suspicion of additional criminal activity. Reasonable suspicion requires specific facts, not hunches. Here is officer move. They completed stop, wrote citation, ran license, checked warrants. You asked if free, they said no. You invoked silence, refused consent. Now they stand there watching you, walking around vehicle, calling backup, requesting K-9. They are buying time, hoping you get nervous or observe something. Field data shows this extends stops 12 to 22 minutes. During that time, officer looks for any behavior to articulate as suspicious. You shift weight, they write appeared nervous. You make eye contact, they write stared, indicating intoxication. You avoid contact, they write avoided, consistent with deception. Everything gets documented, twisted into suspicion. Your response is force officer to articulate justification on camera. Officer, what is your reasonable suspicion for detaining me? This creates record, applies pressure to justify or release you, preserves legal challenge. Officer says stand by. You say, officer, what is your reasonable suspicion? Officer says conducting investigation. You say, what specific facts give you suspicion beyond traffic violation? If cannot articulate, they are violating Rodriguez. If they can, you maintain silence. Lock this phrase. Officer, what is your reasonable suspicion for detaining me? Officer, what is your reasonable suspicion for detaining me? Officer, what is your reasonable suspicion for detaining me? That forces officers to commit on record or release you. But if situation escalates into formal interrogation or you are placed under arrest, you need the nuclear option. Phrase number 5 is that ultimate weapon. Phrase number 5 is, I want to speak with an attorney. This terminates all questioning instantly under 6th Amendment and Miranda versus Arizona. Not reduces it, completely stops it. All interrogation ends the second you invoke counsel. Here is when to deploy. Officer transitions from traffic stop into formal interrogation with detailed questions, or they placed you in handcuffs, or told you under arrest, or moved you to patrol car, or transported you to station. The moment escalation occurs, this becomes immediate counter. Officer, I want to speak with an attorney. Once you invoke counsel, officer must immediately stop all questioning. This is not optional. This is constitutional law from Miranda and Edwards. If officers continue after you invoke, any statements become inadmissible as violations of 6th Amendment rights. Critical distinction. This works before, during, and after arrest. You do not wait for custody. If officers ask investigative questions that could lead to charges, invoke immediately. Here is the exchange. Officer says, we have gotten reports of drug activity in this area. Know anything about that? You respond, Officer, I want to speak with an attorney. Officer responds, I am just trying to clear things up, cooperate, and this goes easier. You respond, I want to speak with an attorney. Officer says, so you are not willing to help, makes you look suspicious. You respond, I want to speak with an attorney. You repeat exact same phrase every time. Every attempt to question gets same response. I want to speak with an attorney. Do not explain why. Do not justify request. Do not add because I did not do anything wrong or because I know you are trying to trick me. Just the phrase. Clean, tactical. This creates unbreakable defensive position. They cannot proceed without violating constitutional rights. Drill this. I want to speak with an attorney. I want to speak with an attorney. I want to speak with an attorney. This is ultimate defensive weapon when situation escalates. Now you have all 5 tactical phrases, but phrases alone will not protect you without correct physical protocol in first 60 seconds. Here is exactly how you handle opening moments to establish tactical advantage. The moment you see red and blue lights activate behind you, execute this protocol. Signal immediately and scan for well-lit visible location. Do not stop in dark or isolated areas. Look for gas station parking lots, well-lit intersections anywhere with visibility and security cameras. Pull over within reasonable distance but prioritize tactical positioning. Engine off the second you stop. Keys removed from ignition and placed visibly on dashboard where officer can see them. Dome light on if dark or dusk. Both hands at 10 and 2 on steering wheel completely visible through window. Do not reach for anything. Do not move hands. Do not grab for documents. Wait for officer to approach and make first contact. Window cracked 2 to 3 inches maximum, not rolled all the way down. Cracked enough to communicate and pass documents, but not enough to give officer unrestricted plain view access to entire vehicle interior. This is critical tactical positioning. When officer asks for license registration and proof of insurance, you respond with this exact statement. Officer, my license is in my wallet in my back pocket. My registration and insurance are in my glove box. I'm going to reach for them now with slow, visible movements. Narrate every single action you're taking. Reach slowly. Retrieve documents one at a time. Pass them through the cracked window opening. Once documents are handed over, both hands go back to 10 and 2 on steering wheel. Then you state clearly for both cameras. Officer, my vehicle is secured. For everyone's safety and for accuracy of this interaction, I am recording this encounter as well. Your phone should be mounted on dashboard or windshield in visible location, actively recording entire traffic stop. In nearly every state in United States, you have absolute legal right to record police officers performing duties in public. This is not confrontational. This is not escalating. This is tactical documentation that protects both you and officer by creating objective record. Now here is critical state-by-state tactical variation. In Maryland and Colorado, marijuana odor alone does not give officers legal authority to search vehicle without consent. In Texas and Ohio, smell of marijuana can still be articulated as probable cause, justifying warrantless vehicle search. In states with stop and identify laws like Texas, Nevada, and Arizona, you must provide identification when lawfully detained. In states without stop and identify laws, passengers in vehicles generally do not have legal obligation to provide identification unless officer has independent, reasonable suspicion they are involved in criminal activity. Know your specific state rules before you deploy these tactics. You have established physical foundation and know all 5 phrases. But if you make these common tactical errors, you will neutralize everything you just learned. Tactical error number 1 is talking after you invoke silence. You clearly state, "Officer, I am invoking my right to remain silent." And then 2 minutes later, when officer asks another question, you start answering again because silence feels uncomfortable. Invocation only protects if you maintain it consistently. The second you start talking again, you have waived protection and everything you say becomes admissible. Tactical error number 2 is consenting to search because you think cooperation will end. Stop faster. You calculate that if you just let them look, they will not find anything and you will be on your way in 5 minutes. Wrong. Average consent search takes 25 to 35 minutes and frequently leads to vehicle impound, even when nothing illegal is found, because officers claim they discovered drug paraphernalia, residue, or suspicious packaging materials or items consistent with criminal activity that justify seizure pending further investigation. Tactical error number 3 is losing composure and getting emotional. You start arguing with officer about whether traffic stop was legally justified. You call them names. You raise your voice. You make accusations. You have just lost all tactical advantage. Stay calm, stay tactical, stay in control. Your composure is your most powerful weapon. Be polite but not talkative. Cooperation does not equal conversation. Tactical error number 4 is not understanding critical legal difference between request and order. If officer says, "I would like you to step out of the vehicle for me," that is phrased as request. You can respond, "Officer, are you requesting or ordering me to exit the vehicle?" If it is request, you can politely decline. If it is order under Pennsylvania versus Mims, which gives officers authority to order occupants out for officer safety, you must comply, but you state clearly, "Officer, I am complying with your order." What is the lawful basis for this order? This preserves your legal challenge while maintaining physical compliance so you do not get charged with resisting or obstruction. And here is field reality that shocks most people when they learn it. Police officers can legally lie to you during investigations. They can claim they have evidence they do not actually have. They can say witnesses identified you when no witnesses exist. They can tell you your co-defendant already confessed and blamed you when that is completely fabricated. They can promise things will go easier if you just cooperate and tell truth when cooperation actually makes prosecution easier and your honesty gives them admissible statements. The only legal exception is officers cannot fabricate official documents like warrants or court orders. Everything else, every verbal claim, every promise, every threat is fair game. That is exactly why your tactical countermove is always the same regardless of what they say. Attorney first. Answers never. Here is the core field rule that wins traffic stops every single time. Control your words, control the outcome. You cannot talk your way out of an arrest, but you absolutely can talk your way into one. These 5 phrases are your complete tactical shield. Am I free to leave? I am invoking my right to remain silent. I do not consent to searches. What is your reasonable suspicion for detaining me? I want to speak with an attorney. Right now, immediately after this video ends, pull up your phone and record yourself saying all 5 phrases out loud. Practice them until words become automatic muscle memory. Because in actual moment of traffic stop, your adrenaline will be spiking, your heart will be racing. Your tactical memory needs to be instant and automatic, not something you are trying to remember. Screenshot these 5 phrases, put them in your phone notes, write them on card, and keep it in your vehicle. Memorize them like your freedom depends on correct deployment, because legally and tactically, it absolutely does. These counter moves only work if you can deploy them immediately without hesitation or modification. This is tactical education only, not legal advice. Always consult with qualified attorney in your state for your specific situation. If this video helped you understand how to protect your constitutional rights during traffic stops, hit the like button, subscribe to the channel, and turn on notifications so you never miss tactical training that keeps you prepared for real-world encounters. Share this video with everyone who drives because this knowledge protects your family, your friends, your community, and every single person who could face a traffic stop. You just learned 5 critical phrases that end traffic stops fast and protect your constitutional rights. But if you want to take your tactical knowledge to the next level, I have got more training that builds directly on what you just learned. The next video in this tactical series is right here on screen. Click it now to keep building your skill set. Tell me in the comments, where in the world are you and what time is it there? Control the interaction, control the outcome.